Good morning, Judge. I'm approaching on Jaime Estrada.
Okay.
He's here for termination of PPI. The SOT, he said he's paid all the fees, but we're still waiting for receipt certificates.
Are you ready? Did you receive word that he's paid everything as well?
Yeah. So the only thing about that, I've emailed it to Brenda. We are waiting on progress report from the CSO. As for an update, I've not received anything.
Okay, so do you have anywhere else to go?
I do have to run to ERD. What time does docket usually end?
But 12:30-ish.
Okay.
You know, I mean, today's a light day, so maybe 12. I don't know, we haven't gotten word. I guess we could roll it to tomorrow to see.
Yeah, I was just gonna say that if we, if I come back and we're still waiting, if we roll it, can we waive him just because he's here today? And
Does he have a receipt that he's paid?
have
you asked him? Yeah, see if he, because they're gonna give him a receipt anytime you pay, you know? He should have a receipt.
Let me follow up.
Yeah, see that, and then so that we know that he actually did pay, and then assuming that he did, then yeah, we'll waive tomorrow.
Okay.
Hey, Judge, can we, deal with the open boards?
Oh, come up, Mr. Lestrade. Let's do this. I'm not going to do anything until this lawyer gets here. All I know is he's got 3 open cases. They're all at 7503 because you continually take off. You come to court when you want to come to court. You don't come to court.
People say don't come to court. He told my the probation.
Let's wait for your lawyer to get here and we'll see. But all I know is you've got 3 open cases. All the bonds are 7503, which indicates to me that you've taken off 3 different times.
No.
So let's see. So just take a seat for me.
On the court for.
I mean, I'm not going to argue with you. I'm going to wait for your lawyer to get here and then we'll go from there.
Okay.
But you're supposed to come to court when the reset says, not when you want to come to court.
No, he told me not to come to court, Judge. He said not.
You can come to court, right? But you're supposed to come to court when the reset says. And we have multiple instances of you not doing that.
Okay.
I mean, I don't know how else to say it. So let's wait for your lawyer to get here and we'll go from there. Just take a seat.
Judge, I already emailed him because he got one of them.
He got another new one, so hopefully and he's usually pretty good about showing up. So. Right. Ready? How are you? You know. Who do you want to talk about first?
Let's do Lestrade.
Okay. Come up, Mr. Lestrade.
So Judge, there was misunderstanding on the case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him to get him to come in. couldn't get in contact with him, then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received a letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case, because I don't know anything about it. Mr. Lestrade, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location.
Right off the bat, you can feel the courtroom juggling act: timelines, paperwork, and verification. But here's the key question. What happens when proof of payment isn't immediately available? In legal settings, even small delays can snowball into bigger consequences. Stay sharp. This detail might matter more than it seems.
It's the same location.
I told you when you first came here not to go back to the Walgreens.
Okay, thank you.
Not once, but twice. What should I do now, Mr. Lestrade? What should I do? You tell me.
Just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment, has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
Yeah, stay at home.
Did you come with mom today?
No, sir. Stay at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat.
Yes, sir.
But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Ray, I'm sorry. I'm not going to give another PR moment. You know, perhaps, I don't know, but you're not getting it.
Can we at least address the bond, though, Judge? Because I believe the bond's at
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today.
Yes, sir.
It goes with you. I'm with you though. 500.
Appreciate it.
We're saying the bond's ultimate time.
I will. Good morning, gentlemen. You are Mr. Lowry. You must be Mr. Benson then. All right, gentlemen, both of you have picked up criminal cases, and it looks like you've worked out an agreement with the state and your defense lawyer. It looks like both of you, Mr. Benson, are charged with theft and you're facing up to 6 months in jail and or a $2,000 fine. And Mr. Lowry, you were charged with criminal trespass as well. You're facing up to 6 months in jail and or a $2,000 fine. The agreement you have worked out, Mr. Benson, is 22 days in jail, credit for the 22 days so that you are done today. You need to understand that this is an enhanceable offense. If you continue to pick up theft cases, at some point they're going to hit you with a felony, and instead of days, you'll be looking at years. From now on, you are now facing a minimum of 30 days in jail. Do you understand? Mr. Lowry, you are with your criminal trespass, they've offered you 122 days in jail with credit for the 122 days that you've done. So likewise, you're also done with us today as well. It will go on your record. You can never take it off. And from now on, you're facing a minimum of 30 days in jail. Do you understand? Is this what both of you want to do? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, there's no turning back. It will go on your record. It'll stay there forever. How do you plead to the offense, Mr. Benson? I'm going to find you guilty. I will follow the agreement, send you to it. Mr. Lowry? How do you plead to the offense? Guilty or not guilty? All right. I'm going to find you guilty as well. I'm going to, if any enhancements, just abandon it.
On the.
Oh, do we need to do it on the
Well, there's
theft?
one with the second conviction. on
Got it.
that.
All right. So, Mr. Benson, you have a prior theft from 2019. Is this true?
Yes, sir.
Okay. This now makes two. A third, you're looking at a felony charge. No matter if it's a pack of gum, a big pack of candy, be careful. You could be facing some serious time next time. You understand? Okay, so true to the first. We'll abandon the other one. All right, good luck, gentlemen. Thanks.
All right, gentlemen. Go ahead.
Oh, and Mr. Benson, your second case will be dismissed.
Okay, this is where things start heating up. The judge is clearly signaling a pattern, not just a one-time mistake, but repeated behavior. And in the legal world, patterns are everything. Mississippi court once, maybe a warning. Miss it multiple times? Now you're testing the court's patience. What do you think? Should repeat absences automatically mean stricter consequences?
I realize you have it. Oh,
Yeah. I was told I needed to approach on Mr. McCullum. He's not here today.
we have quite the, did you represent him before?
No.
Okay, we have quite the history with this gentleman
Okay.
where he's had a couple cases in here with numerous bond violations. He pled not too long ago, or no, I think did it get dismissed or did he plead? I don't know.
One of them pled and the other one got dismissed.
So he's now picked up a new case. All I know is that he's charged with evading arrest. He picked up a new case on the 30th. And we've gotten emails stating that because of this case, I think he broke his leg in half, is what he's saying. He broke his knees, tibia, fibia. I don't know.
Okay.
He's provided Victoria some kind of paperwork. I don't know if it's legitimate or not. It appears to be, but I was going to do probable cause number one to see, was there really an injury that occurred? I don't know.
It says he tripped and fell. The officer indicated that he tripped and fell as he was running.
Mind?
Yes.
Pat, please.
On December 29th, 2024, an officer observed another officer driving through a parking lot of 2901 Westridge Street with emergency equipment on and chirping sirens due to a large crowd loitering on the property with no loitering signs. The officer observed in the left side mirror the defendant toss an object underneath a motor vehicle on the property. The officer made a U-turn and observed the defendant reaching under the same motor vehicle, retrieve the object, and reach into his front waistband as if placing the object. The defendant then tossed the object under another motor vehicle. The officer, wearing full uniform, told the defendant to come towards him and asked what he had dropped. The defendant walked towards the officer, stating he did not drop anything. The officer grabbed the defendant's left hand and attempted to handcuff, and the defendant took off on foot. The officer chased the defendant, and the defendant tripped on a drainage. The defendant evaded for approximately 100 feet. The officer looked underneath the motor vehicle and retrieved an unholstered black Glock. The defendant was identified by his Texas driver's license.
Did he suffer an injury as a result of that trip and fall? Does the officer notate? Because from what the email says is that he went to the hospital at that time? Is that what that says?
Doesn't say anything in the DIMS.
No, and it does not say anything regarding whether he was taken directly to JPC or whether he was taken to the hospital. This is a Houston Police Department case, so we do have the offense report, so I can...
Do you mind looking it up real quick? Maybe just the DIMS doesn't say it. The emails that we've gotten is saying that he's in such pain and such dire circumstance that he cannot make it to court. But I have quite the history with this gentleman where...
Yes, so he was taken to the hospital due to a leg injury. He was taken in an ambulance.
Let's say that.
Yes, Judge.
Okay. So I've appointed you to represent him. If you don't mind reaching out to him to see how bad is it, when can we get him here, how, and we'll go from there.
I did see he has felony on the 30th, so I'll see if I can get in contact with him and find out if he's going to come to that, and if so, we'll just do it the same day.
Yeah, I'm okay with it.
Okay.
Right now, raising our-
Okay, great.
Okay, perfect.
That way you can, now, one more thing. In the past, he has also emailed me with a bunch of stuff before. So when you reach out to him,
Communicate
don't call me, don't email. It's been quite, just please.
Yes, sir.
Yeah, okay.
Are we given, because you said you wanted to about the hospital. So you're saying he's 9 here on the night?
Okay.
Do you want ready or?
I think that's it. I think we're done. What?
You have some plays that are falling around.
On
Approbation and which is overstretching forward. I'm not sure. Garrett is one of them. I want to see if this is Ray.
yeah, I remember. You said Garrett? I'm on.
Snowball. Managed to.
I mean, endless.
Yeah.
This moment is huge. The judge explicitly says the defendant was told not to return to that location, and yet here we are again. That turns a simple theft into something much more serious, ignoring a direct court-related warning. It's not just about the crime anymore. It's about defying authority. That's a dangerous line to cross.
All right, Mr. Lestrap, it looks like you've worked out an agreement. Come on up. I really hope that you heard what I said to you earlier. Every time you go to this Walgreens, they know who you are, every single person. So every time you come back, what do you think they're going to do? They're going to watch you like a hawk. Your every single move. You've been trespassed from there. So if you go back there and they call the cops, you're going to be right back in jail. fine, go back. You've worked out an agreement. They're offering you 60 days in jail with credit for the 2 days that you've done on this theft case here. Looks like they're going to dismiss the 2 other thefts that you have. You also need to understand this now makes at least 2 thefts for you. You pick up another theft, you're going to be looking at a felony charge, years instead of days.
Yeah.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Are you sure you want to do this? Guess that's it, right?
Yes, Your Honor. I talked to him. He understands the nature of the consequences.
Okay.
Has no means of being able to afford bond, so we can look at the newer case. So he's opted to take the agreement on the old case.
If you can't ever make bond, if you don't have anyone in this life that's going to bond you out, then why pick up a criminal case? You know what I mean? When you leave here, Mr. Lestrap, come back. If you want a place to sleep, if you want a job, if you want food, I'll give it to you. All you got to do is come back. But if you keep picking up criminal cases, no more PR bonds. Do you understand? There's no excuse. We will give you resources. All you got to do is come back. You're giving up the right to, well, have I gone through the warnings? I don't remember. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there's no turning back. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty and I will sentence you to 60 days in jail. I will give you credit for the 2 days that you've done. It's not enhanced, right?
I think there's any enhancement.
Okay. All right. All right. Hi. Good luck. Or did he say plead guilty?
Yes, sir.
I didn't hear it.
I didn't plead to the offense, sir. Guilty or not guilty? All right. I'll find you guilty. Sentence you to good luck. Thank you so much, Ray. Hi, come on. Yes, ma'am.
I'm here on Raymond Henderson.
You said Peterson?
Henderson.
Henderson. Okay.
We're trying to work out a few things. I just wanted to know if the court would be willing to give him time or credit for the time that he served out of county before he was extradited here.
Sure, of course. Yeah, I mean, it's young though, isn't it?
I think he's
No. The case.
Oh,
the case.
Yeah.
It's only
Sorry.
right.
I'm sorry. Yes, it's a newer case. He's got about 17 days of credit built up from out of county, and then he also has some credit here in Harris County.
Okay. What offers have you given?
So we gave a 30-day offer, so we're expecting that with the credit to be time served.
Okay. Yeah, I'm down for sure.
Thank you.
Yes, ma'am. Thanks. Hi.
Hi,
Good morning.
Happy New Year.
Happy New Year.
I am approaching this morning on Robert Moore.
War?
Yes, Moore.
More with an M. Okay. Oh, he's not.
Oh, no, that's somebody else. They both have the same last name.
Yeah, I have another case that got moved to Friday. Her last name is Moore.
Is this
And just like that, bond reduced, but with a warning. The revolving door closes today. That's courtroom language for this is your last shot. The judge is balancing fairness with accountability here. But let's be real. How often do people actually take that final warning seriously?
This is a new case?
It is.
16, Your Honor.
Am I bringing them up?
Um,
Oh, this is the case. Okay. Okay. Right. All right. Good morning, Mr. Moore. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 31st, 2024, the officer initiated a traffic stop for the defendant's vehicle speeding 61 miles per hour in a 50 mile per hour zone at the 6100 block of South Highway 225. The officer made contact with the defendant, driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack on the back seat of the vehicle, and the marijuana was weighed, and the weight was 2.87 ounces.
Did you say, you said speeding? Did you say
61 and a 50.
Got it. Okay.
And, Your Honor, if I may, the issue that I have with the PC, so in regards to the speeding allegation, there were 2 cars in front of my client prior to him being stopped. It was 3 a.m. in Pasadena. He had the nicer car, was pulled over. And also my client explained to the officer when he asked him about the smell in the vehicle, he did tell him that he had CBD in the car. He said that I had 3 packs. I just purchased it. They're in my backpack in a bag. They were unopened at the time. The officer did take the bag so that he wasn't, he didn't know how CBD looked or smelled, so he was just gonna find it to be marijuana and would take him in for that, even though my client did prove up the fact that it was CBD in regards.
But if it's CBD and it's unopened, it wouldn't smell, right? Because it's vacuum sealed.
Well, no, he said he smelled something in the car, but the substance that he found in the packages, they were unopened, and those were CBD. That's what he said that he found to be marijuana. But my client let him know that this is CBD, it's in my backpack. When you search, you're gonna find it, it's gonna be in there. But I purchased it earlier today from a smoke shop. And so when the officer did retrieve them out of the backpack and asked about it, he's like, well, I can't tell the difference between, what CBD and marijuana is. I only know marijuana, so I'm gonna have to take you in on that.
What form is this CBD in?
It was like in a little,
Is it?
it was a flower, so.
It is a flower.
So I do know that the CBD flower and cannabis flower, they look very similar, so.
Your Honor, if I may. So as the DIMS establishes, so the odor was enough from the search, and finding that leafy substance is enough because upon further testing, it may or may not. But just for the purpose of probable.
So I think for probable cause purposes, I think it's enough because the odor, right? Now, they're going to test it. If it tests different, then there we may have an issue.
Yeah.
But as far as probable cause, then your record speaks for itself, Mr. Moore. Anytime you get pulled over, what's going to happen?
They gonna search me.
You know what I mean? This is what? 1, 2, 3, 4, 5, 6 marijuana case. Anytime you get pulled over with your record, what's going to happen? Every single time. So why give them a reason? Really, we keep coming back and forth and back and forth and no. Can you run his license if he has?
Eligible, Your Honor.
All right, I'm not going to put any conditions. Just be careful. Don't pick up any new cases because I'm going to lose it at that point. You've got a great lawyer. Listen to her. She'll take care of you. If she tells me she can't get a hold of you, I'm going to revoke your bond. Just be good. Don't pick up any new cases. If you're going to drive, make sure you have insurance, car insurance. All right? Okay, guys.
Thank you.
Yes, ma'am. All right. Hi.
Judge, I have an Anisha White on the docket.
Okay, it's getting up there, but
Yes.
not up there.
So I just asked the state to eval the last time they did. I would like to get a trial date, but
Of course you can.
okay, then I'll do that.
Sure. Yeah, just talk to Ramona, whatever you want.
Thank you, Judge.
of
And I
course.
also have a Coriel Dixon on the docket.
How is Miss Dixon doing?
She's doing well, Judge.
Did you finish it yet or what?
No, her last class was on 12/19. Then they took a break, and they come back tomorrow. She brought her over the break homework and study guides that she's filled out.
Okay.
So she's been working on it. I asked her tomorrow when she goes back to figure out exactly how long it's going to be before she takes the test, because she took the evaluation test already. Those results aren't back yet because that was right before the break. So we should know in the next couple of days, hopefully.
So let's set it off a week to see, and then we'll go from there. And then, but we can do just a longer date, huh?
Yeah, sounds good. Thank you, Judge.
Thanks, bud.
There was a video that's just found in this case.
I know, I saw it. That's why it's.
This is one of the most important legal takeaways in the entire video. What starts as minor theft, something as small as candy, can escalate into a felony after repeat offenses. That's how the system works. Escalation through repetition. So ask yourself, is the punishment matching the crime or the pattern of behavior?
So what, come on up.
Good morning, Judge.
Is he here? Is that him? That's not him, right?
No.
Okay.
My understanding is that he is still home with a sick child. I do have a doctor's note that I showed to the state. I just don't know if that's sufficient for the court, but that's.
Okay. Yeah,
Is he wrong tomorrow or do you want to get on this?
just regular.
Thank you, Judge. I do speak.
Yes, ma'am. You ready? Hey. Come up, Mr. Harrison.
Yeah.
Was today his regular setting, or was it a setting that we brought him in because he has bond violations?
This is regular setting.
Okay.
We had accepted the plea offer and we're ready to move forward today, before I got that email.
I have here that you have bond violation, Mr. Harrison, in that you were continuing to use alcohol. You are entering into a probation now, and I'm warning you that if you test positive again, I can amend your conditions, and I will, to put you into a rehab facility. And I can take you there kicking and screaming, and I don't care what is going on in your life. But if you continually show me that you cannot stop, then I'm going to do it my way. And I promise you, you're not going to like the way that I do it. It is a minimum of 9 months in treatment if you respond well. Do you understand? But it could be in an inpatient facility for up to 1.5 years of your life spent with me in jail. Do you understand? If I didn't get your attention enough last time, heed this warning now, because you will not get another one. You are charged with driving while intoxicated, second offense. They have agreed to reduce it to a first, and I hope that you thank them, because thereby you are now not going to do 5 days in jail, because that would be the mandatory minimum for you if you plead on a second. But I'm going to tell you now, I'm going to keep you on a very short leash, and one false move, they're going to file a motion to revoke. And if they prove it to me that you violated this probation, get ready. For you to complete it, what are you pleading to is 180 days in jail to be probated for 15 months. As part of the conditions, you will do a repeat offender DWI education class. 2 victim impact panels. You must also do a TRAS. This TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, which in my guess they're probably going to, you must fulfill those. It can be so much as intensive outpatient treatment, supportive outpatient treatment. Because you're continuing to drink while you're on bond for this case, it may very well say that you may need inpatient treatment. I don't know, but that's what you're agreeing to now. Do you understand? No drugs, no alcohol, random urinalysis. You must maintain a guardian interlock and a $100 one-time donation to MAD. One more thing that you must recognize here, that there is a requirement for a no breath test refusal. If you are driving in a car and you get pulled over, an officer asks you to submit to a breath test, you must submit to it. If you fail to, then they're going to take you to jail and you're in violation of this probation. Do you understand? You give up many rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. This is number 2. What happens the next time, Mr. Harrison? If I had one strand of hair, every time someone told me that it wasn't going to happen, I would have flowing, beautiful locks. You need to know what happens if you get pulled over again and you get charged with another DWI. What happens next time? You will be facing a 3rd-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, if you even have a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk. You tell me now, it's not.
Now this is intense. The judge isn't just warning. He's laying out a full roadmap of consequences. Rehab, jail time, strict monitoring. This is where the legal system shifts from punishment to forced intervention. But here's the real question. Does this kind of tough love actually work, or does it push people deeper into the cycle?
It's going to happen. You told me you weren't going to consume. Here we are. We've got you on a bond violation. Goes in here, goes out here. The only thing that matters are actions. Your words mean nothing. Actions speak louder than words, Mr. Harrison. How do you plead to the offense of driving while intoxicated, guilty or not guilty? I'm going to find you guilty. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here in Orange. We're going to have a conversation as to whether you violated this probation, and if you did, you were looking at 180 days in jail. Do you understand? Okay. So the other thing that we have to do is the fines and fees for the DPS surcharge. It's a first, so it's a $3,000 fee, but let me ask you this, is this a 0.15 or above?
To Your Honor.
And is it alleged? Is it alleged on the information?
I believe it's alleged to be 0.15.
You should be walking out here with a $6,000 surcharge, but because they reduced it to a first, it's now a $3,000 surcharge. You must pay that in addition to the court cost. If you don't, for every $100 you owe, you will sit 1 day in jail. Do you understand? Okay. How do you plead to the offense? I will find you guilty. I'll send you to it. Good luck, son. Thank you, Ken. All right.
Judge, are you issuing a military license?
He has the portable device at this time.
Okay.
His license is suspended until February 18th.
Okay. Yeah, we need to do a no driving affidavit. You are not allowed to drive. I don't care what you're doing in your life. You'll be signing an affidavit with me today that you're not driving. I hope you're not driving at all. Take it seriously, Mr. Hunter, because if I catch you driving, get ready. Okay. So if he decides to, if he wants to drive, he needs the interlock before he even gets into a car driving. So we have to amend conditions to be able to do that. So he can't just start driving. You cannot just start driving. You are required to have an interlock in your car. There is a paper that we sent to DPS so that every officer in the state knows that if you drive, you're supposed to have an interlock. You get pulled over and you're driving and you don't have that interlock, they're going to take you to jail. Do you understand? Okay, talk to Kim. She can help you out when that time comes.
Thank you so much.
Thanks, Kim. So the 3,000 plus the court cost, who's going to pay all? Carl, hey. Yes, sir.
You ever had long over there?
I did. Man, when I was 19, my hair was so beautiful. Oh, man, it was like,
History 19.
I know, it's beautiful. Where the times are gone.
I have had a Christopher Gomez on your docket yesterday.
Yes,
I was not here because I took my wife to the doctor.
don't worry about it.
It was reset till January 22. However, you apparently signed the VDR. I guess it needs to be
Undone?
undone or rescheduled for one.
It's not on today?
We got a felony case pending.
You got a cause number for me?
Sure.
Okay. All right, what?
2544095. You got two cases. You better pull up one. He's got a felony case pending at 2:30 that was reset till January 17th. And I think the reason for the VDR is because of the felony. I'm not sure, but it doesn't really matter anyway. Just need you either set it for the 122 or undo it, whatever you want to do. Coordinate. It's already, the case is already reset to 142.
You see what he's talking about?
Yes, so the PDR was signed and one of them is listed as in custody.
Right, so you want to put it, I guess I can just change the date, put it on that day.
Right, I had only put it out to the felony because I didn't know if it would come back this week or.
Do you want a different day or do you want that day? Okay, yeah, so we can just change the date on that and put the 122 on it and it's,
Keeping it like set for law enforcement to address the DVR or we're just using this?
he's in custody. I mean, there's just, it's redundant. There's just no need. Sure, yeah. Where is it?
It's on the case number ending in 489.
Okay, this other
Ready for activities, because you signed it already.
25424.
Oh, it's still in ready for activities. Oh,
Yeah.
got it. Okay, done. For sure.
So you're gonna continue supervision?
Yeah, I'll just continue because, I mean, really.
What's the last name again?
You ready for cause number?
25424. Thank you.